The Tom Woods Show, episode 1885.
Prepare to set fire to the index card of allowable opinion. Your daily dose of liberty education starts here. The Tom Woods Show.
Hey folks, for a limited time, Harry's Razors have made their exclusive offer even better for listeners of this show. New customers can get a special offer and a Harry's starter set and body wash at harrys.com/woods. You'll get a 5-blade razor, weighted Truman handle, foaming shave gel, a travel blade cover, and a travel-size body wash. Go to harrys.com/woods to redeem that offer today. Hey everybody, Tom Woods here, delighted to be joined once again by our old friend Kevin Gutzman, who's a professor of history at Western Connecticut State University. He's the author of numerous important books, including James Madison and the Making of America, Thomas Jefferson Revolutionary, and The Politically Incorrect Guide to the Constitution. He and I also wrote a book together called Who Killed the Constitution? The Fate of American Liberty from World War I to Barack Obama. And as you may know, this may seem unrelated, but you'll see the connection in a minute, I've been doing a cartoon series with longtime Tom Woods Show guest Michael Malice. And the series is called The Politically Incorrect Guide. And in each episode, we look at a different topic. Well, we recently did an episode on the Supreme Court, and I like to have an episode of this podcast in tandem with these cartoon episodes to discuss that topic and maybe even to promote the related book in the Politically Incorrect Guide book series. Well, Kevin's Politically Incorrect Guide to the Constitution is the book for you to read in tandem with that cartoon series. Now, if you haven't been watching it, you can catch up on episodes at pigseries.com. That's P-I-G for Politically Incorrect Guide, pigseries.com. Anyway, so today I just wanted to have a conversation about the Supreme Court, about court packing, and some issues that are relevant to us these days. Kevin, welcome back to the show.
Happy to be here, Tom.
Got some Supreme Court things to ask you about in tandem with the release of as I was telling you, the cartoon episode on that subject. I'm a month behind. I totally forgot to do an episode on this subject, so now better late than never. And I sent you an article from Slate about Amy Coney Barrett, so we'll get to that in a few minutes. But you are the author of The Politically Incorrect Guide to the Constitution. So can you tell us, from the standpoint of somebody who would write a book like that, what should we think about the Supreme Court? What is it really supposed to be? Should it be an institution that we're arguing about this much and we feel like our entire way of life is threatened because of it?
No, it shouldn't be. It should be just applying the law and the Constitution. But from a very early point, the court dove into politics, and at various times there have been majorities that have gone far toward remaking the Constitution. Most notably, you have the period when Franklin Roosevelt was appointing essentially all the members of the court, and it went from saying that the federal government only had enumerated powers to the federal government could do essentially whatever it wanted to do. So that's where we more or less are now with various refinements. We've just been through more than 83 years of a period in which the court let Congress create administrative agencies to legislate and adjudicate. And it also allowed Congress to legislate about whatever immediate policies it wanted. So we've come to have massive federal involvement in local public schooling, for example, and in deciding how to pay for roads in every town in America and such. And all of this was rightly ruled unconstitutional up to 1937. And now, well, we just kind of take for granted that the state government's chief activity will be funding federal programs. That's what the legislature in Hartford, the state legislature of Connecticut, where I live, spends most of the money it spends on doing, implementing federal programs. So the Supreme Court, in other words, has not done what it was supposed to do. It has not held the federal government within the bounds that were supposed to have been set by the Constitution. In fact, even as I'm saying bounds that were supposed to have been set, people listening to this probably smile at the very idea. It's so passé.
Yeah, exactly. I mean, I almost roll my eyes now when I hear naive conservatives talk about this. And we just have to get back to the original. You have every possible power center against you that has absolutely no particular interest in getting back to any kind of limited government or anything like that. Very recently, we saw the introduction of legislation that would expand the court from 9 to 13 justices. Now, it's a commonplace to point out that the Constitution does not have the number 9 in it for number of justices, so it's not strictly unconstitutional. It's just a break with longstanding tradition. And it's pretty obvious what the break is all about, just as obvious as it was in the 1930s. I mean, initially FDR tried to pretend it was because the justices were old and he was helping them out by adding more of them. But then it was pretty clear to everybody. It was that the court either was striking down his legislation or could potentially strike down future legislation, and he wanted activist judges on the court. So what's your commentary on the current drive to expand the court, and do you think it's likely to happen?
Well, I don't think activist is really the right word for it at this point. A judge who wanted to continue on the road we're on would be anti-activist.
Yeah.
And in fact, this is more or less the position that's being taken by people on the left now. We don't want activist judges actually enforcing the Constitution. That would have horrors. Well, who knows what, dogs and cats living together. So this is what people seem to be afraid of. And my view is, I think both that, as a practical matter, the government that has resulted from just allowing Washington free rein has turned out to be far inferior to what we might have expected if we continue to have a highly decentralized government in the United States. And, of course, from a philosophical point of view, I think it's preferable to have local control over local problems and local people deciding how much to spend on local roads and schools and bridges and whatever. So it doesn't strike me as being a good thing in any way, really. It was the case when Roosevelt came up with this court packing idea that there was not equally apportioned bipartisan opposition, but there wasn't only opposition from the then out party, the Republicans. There also was substantial opposition from Democrats.
Yep.
And so this is one reason why we've continued to have 9 justices down to the present. Of course, another one is that it turned out that one of the then justices was already en route to changing his position. So Roosevelt ended up getting what he wanted pretty quickly anyway. But the bottom line is, I think that there's really not any theoretical justification for the model of government we have in the United States now. And there's a superior one for the kind of government to which people in the 18th century consented, or it might be the kind of state into which people who've immigrated since then thought they were immigrating. They were told they were when they swore their oaths of citizenship. So I don't like what the Supreme Court has done in remaking the government. Now, you might think, well, those elected officials in Congress, they didn't have to behave this way. But the thing is, once the system has been remade, it's inevitable that you're going to have people bidding about how much money can be spent on this and that, right? I think that the structure is more or less determinative of the kind of policies you're going to end up with. So that, you have Henry Clay's idea of road policy. Well, that's not surprising once Congress has unlimited authority to borrow and is allowed to spend on whatever it wants. That's one example.
You were saying that in the 30s there was, if not equal bipartisan opposition, still some degree of bipartisan opposition to expanding the court.
Right.
I haven't surveyed or I haven't looked at what the Democrats as a whole think about this right now, but my guess would be that the opposition to it would be more muted now.
Well, I haven't heard Democrats opposing it, but I infer that President Biden's appointment of a commission to study the question of court reform was intended by him to slow the progress of this impulse. So,
which is what the appointing of a commission always does. That's always what it means.
Yeah, and of course, Biden, having been in Congress forever, knows that. So I have a feeling that this is a faint glimmer of the old Biden before he seemed to have lost most of his mental powers. This is kind of what he stood for was, he was a moderately progressive Democrat, but he wasn't going to undertake radical moves like remaking the Supreme Court in the name of temporary partisan advantage. And in fact, it's now famous that when he was chairman of the Senate Judiciary Committee, he at one point said in a Senate Judiciary Committee meeting that he thought that President Roosevelt's proposal in 1937 was, these are Biden's words, a bonehead idea. So that wasn't an abstract philosophical comment. He thought that as a political matter, I think, it would be a bad precedent to be remaking the court for today's partisan advantage, because obviously if you add, for example, if you added 4 justices now so that there'd be a 1-vote Democratic advantage on the Supreme Court, next time the Republicans took control, they'd add 4 justices. And you end up with, 400 people.
Yeah.
I guess 401, 401 people on the Supreme Court, right? That's where it would have to end up, or there'd be other more radical changes. And these aren't desirable. But the bottom line is, of course, that as usual, the real problem is that people don't pay enough attention to these kinds of things. And so what'll be the outcome in Washington is, to some extent, a matter of personalities, not so much a matter of public investment. And what I mean by that is, I think that in 1937, your average eligible voter really had more of an idea of this kind of thing than he does now.
All right, let's dig in a little bit to this article I sent you. I'm going to link to it at tomwoods.com/1884. Dahlia Lithwick on Slate. It's called "A Different Kind of Supreme Court Reform is Already Happening." Subtitle: "The Left is Finally Paying Attention to the Court, and It Might Be Having an Impact." Finally paying attention. The left hasn't paid any attention to the court up to now, Kevin. All right. I like from this very first paragraph, which is just all hysteria, we have, let's see, maybe it's in the second paragraph, but she uses the phrase, she calls the court, as it presently is constituted, dangerously activist and unrepresentative. And I wonder how you'd comment on that. I mean, she is using activist in the sense in which you were hinting at before, because by activist, she just means actively saying the court should not intervene in X, Y, or Z, and the states can do X, Y, or Z if they want to. That's apparently activism. But unrepresentative, what a weird idea. What does that have to do with the court? The court's just supposed to apply the Constitution. It has nothing to do with, well, we need people with this or that perspective. There's not supposed to be a perspective. It's supposed to be, this is the Constitution, we apply it. Most decisions have nothing to do with the court. They have to do with you, your community, your state. They have nothing to do with the court. So the court has nothing to do with being representative.
Well, sure. And she repeatedly gives us a taxonomy of liberals, moderates, and the extreme right on the court, right? So there are no conservatives. There are extreme right-wing justices, moderate justices, and liberal justices. And it's almost as if this essay were written to be a caricature, right? But you can see that this is just the kind of language that people who are writing for this kind of audience are going to use. And I'm guessing that the people who read this stuff don't even notice that there's no such thing as an extreme liberal, right? Or there's the middle and the far right. The liberals, the middle, and the far right. That's, at one point, that's the way she describes these people. Well, of course, in theory, representation on the Supreme Court should not be an issue. In theory, yes, you have a constitution. It's a written constitution. There was popular ratification. That implies that the Constitution ought to be understood as the populace understood it when it ratified it, right? So, of course, that last has come to be a very controversial perspective. I guess she'd probably call that a far-right position, although it used to be everybody's position. And people would just argue about what the ratifiers meant. And, of course, what she means by dangerously activist, for example, one group of decisions that have been extremely or radically or dangerously activist has been concerning people's right to continue having religious services during the COVID lockdowns, right? This is supposedly carving out a new favored group in American society, right? If you're allowed to go to your synagogue on a Saturday, despite the fact that everybody else is being made to stay separated, then you're a favored minority. I don't know what world these people live in, really. She says that people on the left are beginning to pay attention to the court. Well, one thing to notice about this is that since 1937, they haven't had to worry about these kinds of questions. And by these kinds of questions, I don't mean that the far right will be imposing its views through the court. I mean that the left will no longer be imposing its views through the court. That's really what the issue has been. Will the left continue to impose its views via the courts or not? The left's position has been yes, and the right's position has been no, the court should be neutral. So nobody's arguing for, you might say, well, this is one reason for what George Will calls the perpetual leftward ratchet, right? If the only changes that are ever significant are leftward, if the right just wants things to be neutral, then can you avoid a situation in which policy always moves leftward? It's an interesting question. American history seems to have answered it. So anyway, I think it's an overheated piece, but again, I think this is the kind of piece that her audience is looking for. So,
but on the other hand, does she make a point, just a factual point, that Barrett, as some people warned, has not turned out to be the great standard bearer that we were promised? that she's another, if you thought she was going to, for example, for a second, you thought she was going to challenge allow challenges to the election results or something. Yeah, I don't think you get this woman at all.
No, but who really thought that? I think maybe if you got all of your information about judicial politics from MSNBC, maybe you'd think that, or from Slate, maybe you'd think that, but this has not been what anybody's been advocating, right? That's not the position, and it's nothing like Judge Barrett's actual legal persona or her career as a legal scholar. So it's somewhat perplexing. I understand that where there's a market, demand will be met, but what I don't understand are people who read this kind of stuff over an extended period of time, because it just doesn't reflect reality. It's not the way things actually have worked. Some people might say, well, it would be a good thing if this were the way things had worked. I actually am not one of those people, but I do find it highly problematic that we're always arguing about how quickly we should move to the left, right? Or how much the Constitution should be distorted in order to move further to the left, or whether we should have. Notice how worthless this shows the GOP's opposition to what happened in 1937 to have been. The instant there was a conservative majority on the Supreme Court for the first time since 1937. That's what happened during the Trump administration. 3 Trump appointments meant there was a conservative majority on the Supreme Court for the first time since 1937. And the instant that happened, we're immediately talking about, should we expand the court? Should we, it's serious talk too. So the Republicans never talked like that at all, as, the social and criminal law of our country was completely remade by federal judges, usually over the people's resistance, according to all the polling results.
Well, I think this is a case where what Jeff Dice says is quite applicable, that the difference between left and right is that the left is serious. The left really means it.
Yes, right. It's so pathetic. I may have mentioned this to you before, but when I was an undergraduate at the University of Texas in the 80s, I knew these 2 guys who had immigrated to Texas from Britain, where they had both been, young political activists in the Tory party, where Mrs. Thatcher was the head of the British government. And one time I asked one of them, well, what do you think about our parties in the United States? And he said to me, well, the Democrats want socialism now, and Bob Dole says, let's wait till Tuesday, right? That's basically the difference. So, and of course, a compromise always ends up being, well, we'll go halfway to what the Democrats are asking for, So this talk about expanding the court really has underscored the extent to which Republican response to, and it wasn't only Republican, right? When this happened, there were still lots of conservative Democrats, right? The conservative response to the change of 1937, which launched us on this long period of significant policy making by federal judges was completely feckless, right? It was null sign. I don't know how else to describe it.
I don't know how to explain this, that not only does that happen, and it always happens that way, with the right acting like that, but then they go and write books about how they're winning and the country is moving in our direction and wasn't Ronald Reagan a great guy and all that. And meanwhile, absolutely everything they cherish is being taken from them, defiled, stomped on, smashed, and they're writing books about their great victories. It's insane. I mean, it's like we're being put through some kind of psychological, I don't know, weird psychological ordeal.
It's true. The changes are just impossible to fathom now. We talk about the question, how we could have systemic reduction in criminal penalties. It's just my own feeling is, I actually had a law professor when I was a law student at the University of Texas who was asked in a conference what he thought about the latest Supreme Court exercise of new rights creation for criminal defendants. And he said, well, I don't like it, but I generally don't like this kind of behavior because I'm more likely to be mugged than to be arrested. Well, that's my feeling. I'm far more likely to be mugged than to be arrested. So I don't like creation of unfounded quasi-constitutional rights for criminal defendants either. I want the actual rights in the Constitution to be enforced. But I don't want just spur of the moment invention of non-rights so that people who've committed crimes for some arbitrary reason don't have to pay any kind of penalty, right? That's just one small sliver of the kind of activity that the federal courts have been involved in since 1937, which would have been unthinkable before 1937.
Now, at the same time, though, even though we can say that that's a major turning point, in your own work, you have identified much, much earlier problems with the courts. I mean, maybe not as radical in their implications as this, but certainly very early on, Chief Justice John Marshall was causing a lot of problems. Now, John Marshall, I think himself would be not necessarily on board with what the court is doing these days. But what can you tell us about other turning points, maybe in the 19th century or even in the 18th?
Well, it's true that Marshall was responsible for establishing a set of what are now classic Supreme Court precedents that made our system more national than it was supposed to be. That is, gave Congress or recognized in Congress more legislative authority than Congress was supposed to have. Or another way to put that is established that Congress could legislate in more areas than it was intended to be allowed to legislate in by the people who agree to the Constitution. And that's significant. I don't deny that that's significant, but I think that's that's light years away from having a federal official decide what kind of light bulb is currently glowing on my face as I speak to you, right? Or deciding where the roads will run in my town, or what kind of health insurance the people who work on them have to be provided, or, it's just now there's nothing that comes to mind that the federal government isn't involved in. And you're right. I don't think John Marshall had any inkling of that. I don't think that was even something that anybody considered. So it's true that I'm not a huge John Marshall fan, but I take his idea of the federal regime any day over this one we have now. And again, it's not hostility to the idea of having a federal government at all. The problem is that we've come to have essentially an unresponsive bureaucracy, whether it's under the name of bureaucracy or under the name of federal judiciary, that can decide any question it wants to decide. It can impose any policy it wants to impose, as this article from Slate takes for granted, right? Of course we should have, she says, of course we should have federal judges making these decisions or keeping state legislatures from making these kinds of decisions. And it's really frightening and threatening and awful and far right and so on that we should return to local decision making. I don't find that idea frightening and awful. It just seems Republican to me, lowercase r, of course. So that's that's the main difference between Marshall's becoming Chief Justice in 1801, serving until 1835, and then, on the other hand, this change in 1937 that's completely remade our system, right? Completely just collapsed it all into one national soup, I think.
Hey, folks, time to say something for our great sponsor, Harry's, the official razor of the Tom Woods Show, which I could not live without. With Harry's, you get a great shave at a fair price, and frankly, I don't even care about the price when it comes to razors. I just need a close, comfortable shave and not be a bloody mess at the end. It's like mattresses. I'm going to be spending 8 hours a day on them. I don't care what the price is. I want the best one there is. The benefit of Harry's is that they're outstanding and they're inexpensive. I've been sporting a beard for a couple of years, but as I've told you, I ain't no neck beard, so I do have to shave the neck, which is the most sensitive area, and it's so smooth and close and comfortable, I almost can't believe it. Harry's is a young brand, but they've embraced centuries of blade-making tradition. They bought a German razor blade factory that's been making blades for over 100 years. Their craftsmen grind strong steel into a Gothic arch shape, creating a blade that's strong at the base and sharp at the tip. Well, for a limited time, Harry's has made their exclusive offer even better for listeners of this show. New customers can get a special offer and a Harry's starter set and body wash at harrys.com/woods. You get a 5-blade razor, weighted Truman handle, foaming shave gel, a travel blade cover, and a travel size body wash. There's never been a better time to try Harry's. Go to harrys.com/woods to redeem your offer today. I remember at the time of Ruth Bader Ginsburg's death, we had a lot of people very sad and wanting to honor her. And the gist of it was, I admire her because on the court, she stood up for what she believed in.
Right.
And what I responded, I said, that goes to show that neither you nor she had any idea what the role of a Supreme Court justice is. It's not to stand up for what you believe. Who cares what you believe in? I mean, honestly, why would we care what you believe in? That has nothing to do with your job.
Yeah, I actually saw her once giving a talk at the National Constitution Center on C-SPAN, and she was talking about a bygone Supreme Court justice. And she said, you know, what I admire about him is that, of course, he always wanted to get the right result, but he always wanted to make the right argument. And I think, okay, so this is a Kinsley gaffe, right? This is telling the truth when she probably didn't mean to, because what she's saying is, well, he was always going to reach whatever outcome he wanted, but then he was going to know how to couch it, right? In other words, it's just propaganda. The arguments are propaganda. That's the way they look at these things. So this person who wrote this Slate article has the same idea, right? A judiciary, it's just politics by other means. So we should have politicians by another name. And I don't think that's appropriate. And here's another thing. People take an oath when they enter on one of these offices, right? When you become a Supreme Court justice, you swear to uphold the Constitution. That doesn't mean I swear to do whatever I want, or at least if it does mean that, it's kind of facetious exercise that you're being made to swear you'll do whatever you want. What can possibly be the point? So it's a kind of burlesque of oath taking at this point. I wonder whether there was anything Ruth Bader Ginsburg thought she could have done as a Supreme Court justice that would have violated her oath. My guess is, of course, no, there wasn't.
Yeah, I mean, that's a legitimate question. Right. Well, let me, I want to keep you only for the time I said I would. So let me wrap up with this question. I know probably sometime in the, almost 8 years I've been doing the show, I asked you something like this. But if I were to, and I'm not 100% against Hillsdale College. There are good people at Hillsdale College. Just an example. If I were to look at a Hillsdale College course on the Supreme Court, or if I were to listen to a Heritage Foundation lecturer tell me about the Supreme Court, how would what I'm hearing from them, from the bowels of Conservatism, Inc., be different from what I would hear from Kevin Gutzman?
Certainly you would get admiration for John Marshall. So in other words, the federal principle that I think is the primary element of the Constitution, it is a kind of convenience or just an administrative feature as far as they're concerned. It's really supposed to be, in my estimation, of federal government, and theirs it's a national government. So while it may be that they think it's supposed to have limited powers in some sense, they don't think that's as important an attribute of it as I do. I think that the revolution was made in the name of independence for 13, as the Declaration of Independence says, 13 free and independent states. And they leagued together as United States to make a war for independence. But then they didn't agree that they would just have their government collapse into one central structure. And I don't understand from my study of the ratification process of the federal Constitution that was what the people who agreed to live under the federal Constitution meant by it. So that's the main difference between the people at Hillsdale and me. They think that it's supposed to be a more national government than I think it's supposed to be. And I guess that gets to the critical things I was saying about John Marshall earlier.
You would think after the experience we've had with the Constitution and this understanding of the role of the court and all that almost anybody at this point would say, wow, I was wrong. I mean, we need to go back and tip our hat to Jefferson and his compact theory and strict construction and all that, because and even that might not be enough, but I certainly can't continue with my Hamilton Marshall way of thinking, right? You'd think that, but I mean, what would have to happen for them to say that? What would have to happen for them to say, this hasn't really worked out, and maybe even we have given too much leeway to the court and the federal government?
Well, Jefferson said that he thought the chief flaw that had developed in the federal Constitution was that there was no check on the federal judge's ability to make the Constitution say whatever they wanted to make it say. That is, there was no Republican check on the unelected federal judges. And of course, subsequent events have borne that out even more strongly than what he was thinking of when he said that, right? So I agree with him about that. And again, I think while if you asked them what they thought about it, people at Hillsdale might say, well, yes, it's true that the government has come to be more centralized than it should have come to be. I don't think they would find the same, or they would point to the same origin point for this train of developments as I would. Well, or another thing I mentioned a few minutes ago is I think that the conservatives have failed to use the mechanisms they had in hand for checking federal judges when they behave this way. And again, the fact that the moment after 83 years, the left ceased to have a Supreme Court majority, they were instantly talking about expanding the court, cutting off jurisdiction. In other words, doing what they could do to check its power shows just how unserious the Republicans, the conservatives, have been. They didn't use any of those mechanisms at all. They appointed people. They often had people who turned out to be as devoted to judicial imperialism as the people they were trying to replace. But that was the only means they tried to use to change the court's performance was just making appointments. Alas, it doesn't seem that they were serious. And I think if you take the body of Supreme Court precedents today and compare it to the ones we had in, say, 1975, you see that, wow, there isn't much in the change that's made the country more reflective of the basic moral postulates to which Americans generally subscribe. It's not that it's a wacky position to say, wow, this judicial legislation, not only was it not Republican, lowercase r, but it wasn't reflective of what people wanted. And, some of the key precedents that I'm referring to have always been opposed. So, for example, I'm not advocating this, but in 1962, the Supreme Court handed down a case called Engel versus Vitale that struck down an anodyne, non-sectarian daily prayer in New York State public schools. And 49 governors signed a letter to President Kennedy saying this needs to be reversed. 49. The polling at the time showed that more than 80% of Americans opposed Engel versus Vitale. And since then, every poll that's ever been done has shown more than 70% of Americans oppose the holding in Engel versus Vitale, which not only has been unpopular, but is completely contrary to the Constitution, which intentionally left these questions to the states, as you see if you read the first 10 amendments. Yet nothing's ever been done about it. There's not even any talk about it. Nobody who's quote unquote on the right says, well, one thing that needs to happen is we should reverse single versus vitale. Even if you don't want to have anodyne public school prayer, which actually I don't want to have, this is contrary to the Constitution. Nobody says that. So we just kind of move on. And then what's the next thing, right? Well, if every step is in the same direction, after a while, you've moved a long way. And that's what's happened. And that is just one example, one illustration of the fact that people oppose it. Americans have opposed it. It's not as if this were somehow reflecting the general opinion in a way that our Republican institutions haven't done. It's that we've gotten, kind of the ethics of Harvard Law School and Yale Law School over time.
Well, let me say something as we wrap up. And I said this at the time your book came out, The Politically Incorrect Guide to the Constitution. It seems like a lifetime ago when that book came out.
It does.
But when that came out, I read that cover to cover, of course, and I walked away saying, this book is so much better than my Politically Incorrect Guide to American History that I'm not saying this to butter you up because I have no real need to. But I honestly felt like I don't even belong in the same series with this guy. Like, that's how good of a job you did on that book. There is nothing else like that book. There, as I say, there's the Heritage Foundation stuff about the Supreme Court or whatever, all this predictable stuff. But your stuff is the real hardcore things that if we actually want to have some victories, we need the knowledge that you are imparting in this book. So even though it's been out a while, it doesn't matter. The information in there is evergreen, and people need to have it. So I'll link to that book at tomwoods.com/1884. How's that, Kevin? How's that for a plug?
Well, thank you. I think it was then, and it remains now, the only Jeffersonian account of American constitutional history in print.
And that is pretty insane, isn't it? I mean, that really...
I think it is.
Yeah,
yes.
It really is crazy. I mean, you can read Abel Upshur going through and critiquing Joseph's story in the 1830s, but no one knows who he is. No one reads that thing. It's barely in print. No one knows anything about that. And yet that demolishes the nationalist view of the Union completely. Like, it's left in tatters, but it's not taught to anybody. So therefore, it's just gone. It's crazy. But we have the internet, so you can convey this information. The only problem now is how many people give a darn. That's the real question we face. Well, Kevin, thanks again for your time. I appreciate it.
You're welcome.
All right, folks, I need to tell you that tomorrow's episode you just absolutely have to listen to. You have to listen to tomorrow's episode, 1885. It is about an extremely important project, the most important thing that we can do, I think, right now for the long term, for the future, to try to make sure that what we laughingly call our public health establishment doesn't get away with nonsense like this again and isn't able to claim that they saved us from an even worse fate with their ridiculous guidelines and everything else. That's got to be smashed. We just cannot allow that to ossify into the conventional wisdom. We have to fight that with everything we have. And in tomorrow's episode, I'm going to talk to you with a special guest about an important way to do that. So I really, I know sometimes I have some people who listen to every single episode. Those people are the salt of the earth. I understand if you can't get to every Tom Woods Show episode, but this is one you cannot skip. When this one shows up, 1885, you got to say, oh yeah, old Woods told me I got to listen to this one. Yes, he did. I'm putting my money where my mouth is in this episode. So I urge you to check that one out. Geez, what could this be about? Well, you're just going to have to wait and see. So thanks so much for listening, everybody. See you tomorrow.
Become a smarter libertarian in just 30 minutes a day. Visit tomwoods.com to subscribe to the show for free, and we'll see you next time.
Like the sound of The Tom Woods Show? My audio production is provided by Podsworth Media. Check them out at podsworth.com.